Hi, Gary DeWaal here for Bridging the Week, September 2nd to 6th, and today is September 9th, 2013. Good morning. It would be unfair to say that last week was the slowest week of the year regarding regulatory news impacting financial services firms worldwide. However, one of the most significant regulatory developments I could find was a press release on the website of the Australian Securities and Investments Commission heralding, quote, improved pet insurance disclosure, end of quote. Perhaps it wasn't one of the most active weeks of regulatory news either. That being said, there were a few very important items last week worth reviewing. First and foremost, with the media reporting that the U.S. Commodity Futures Trading Commission will imminently release its final rules on enhanced customer protection prompted by the collapse of MF Global and Peregrine Financial Group, two international regulators, including the CFTC and the Financial Conduct Authority in the United Kingdom, both announced last week enforcement actions against firms for violating current customer protection rules. In the most significant of these two matters, in the UK, the Financial Conduct Authority brought and settled an enforcement action with Aberdeen Asset Managers and Aberdeen Fund Management, large asset managers, for payment of a fine of Great Britain pounds 7.2 million or US dollars 11.25 million related to their failure to protect client funds as required under law. According to FCA, from August 31st, 2008 through August 31st, 2011, the respondents failed to recognize that certain monies it placed with banks on behalf of their clients were governed by UK's client money rules, and therefore they did not obtain appropriate acknowledgments from such banks holding the funds regarding the nature of such customer funds. These customer funds were typically invested in money market deposits. The Financial Services Authority, the predecessor of the FCA, previously had requested respondents, as well as other industry firms during an industry-wide sweep, to confirm that they were fully compliant with all relevant customer protection rules, and they did so in 2010. In the USA, the CFTC brought and simultaneously settled an enforcement action against Macquarie Futures USA for its failure to maintain adequate funds in its so-called secured accounts as of close of business for 1 day. Secured accounts are the type of accounts where funds are held in connection with a U.S. FCM's customers' non-U.S. futures trading. In this case, Macquarie Futures' failure originated from a Halley's Comet once-in-a-lifetime type event related to ICE Clear Europe's conversion of energy swaps to energy futures. Even though Macquarie Futures self-reported and corrected its breach the following day, and even though the firm had sufficient funds set aside for its customers overall in all its customers' funds protection locations, because approximately 38 million US dollars of the funds were in the wrong customer protection bucket, the CFTC brought this action. For this matter, Macquarie Futures were required to pay a fine of 150,000 US dollars plus prejudgment interest. This action makes you wonder what type of enforcement actions the CFTC may take when it sees material compliance issues disclosed by registrants required to file their 2013 annual compliance reports with the Commission during the first quarter of next year. By the way, I have a very good piece, I think, on practical tips related to preparing and filing an annual compliance report on my website. Check it out. A couple of developments related to the centrally cleared and non-centrally cleared derivatives world also made news last week. First and foremost, the Basel Committee on Banking Supervision and IOSCO released the final framework for requirements for non-centrally cleared derivatives that should be adopted by international regulators. According to the framework, all financial firms and systemically important non-financial firms will have to exchange initial and variation margin appropriate in light of the counterparty risk for each derivatives transaction. An initial margin will have to be exchanged on a gross, not net basis. Good news, however, no initial margin will have to be exchanged in connection with FX forwards and swap transactions. The framework also proposed restrictions on receiving firms rehypothecation ability of a counterparty's initial margin deposits. The agencies recommended that these margin requirements be phased in over time. Second, ESMA last week issued its advice to the European Commission regarding the equivalence of non-European derivatives rules to EMIR in 6 jurisdictions: Australia, Hong Kong, Japan, Singapore, Switzerland, and the USA. Under EMIR, a non-EU central clearing counterparty, or CCP, or trade repository can only offer its services to EU citizens if the EC finds its oversight regulations equivalent to EMIR. If equivalence is found on other rules in connection with a derivatives trade between an EU-based and a non-EU-based entity, the parties may choose to apply the non-EU-based entity's relevant rules to the transaction. In general, all relevant rules of the USA were judged conditionally equivalent, while all CCP rules of the other countries were assessed also conditionally equivalent or equivalent. The jury is out, however, on most of the other jurisdictions' other rules. In connection with one of the discussed jurisdictions, last week regulators in Hong Kong released conclusions emanating from the consultation regarding the scope of activities to be regulated under Hong Kong's OTC derivatives regime. In general, there was support for proposals to extend the licensing regime to cover intermediaries that conduct derivatives activities, that there will be a transitional period in connection with implementing such regime, and that the Hong Kong Monetary Authority and the Hong Kong Securities and Futures Commission should have effective regulatory authority over systemically important market participants. A bill incorporating these proposals was introduced to the Hong Kong Legislative Council during July 2013. And briefly last week, the Financial Stability Board issued a progress report on the implementation of the post-2008 G20 recommendations for strengthening worldwide financial stability. Frankly, you have to take the results with a grain of salt. Although the report acknowledges that the end of 2012 deadline to essentially clear and trade on exchanges or electronic trading platforms all standardized OTC derivatives contracts was not met, the FSB gave the status of this policy development a grade of green. This means that the track is developed consistent with plan. Wow. Did the FSB's grading criteria, why did it not apply when I handed in my papers late during college? The CFTC also issued last week a no-action letter that permits commodity pool operators of registered funds that trade on behalf of controlled foreign corporations under certain circumstances to report for financial reporting purposes a registered fund and its CFC on a consolidated basis. However, importantly, this relief is not self-executing. Eligible CPOs must file a notice of claim in advance of the CFTC containing certain required information. And finally, the NFA proposed adoption of a new rule, NFA Rule 2-49, relevant to swap dealers and major swap participants, that would make a violation of certain of the CFTC rules a violation of NFI requirements too. Am I seeing double or what? Well, that's it for Bridging the Week, and until next week, have a great week. And by the way, for good order's sake, let me make it clear that I personally am in favor of improved pet insurance disclosure. Goodbye.